I My name is Leslie Ann Saint Moore. I'm the campaigns director with Raven. I am a member of the Bonnechere Algonquin First Nation and have both Algonquin and settler heritage. And I am joining today from Vancouver, the traditional territories of the Musqueam, Tsleil-Waututh, and Squamish people. And I am thrilled to be joined by my colleague and friend, Pam Hrick, who will be joining us today. And Pam, I would love to introduce you, but you'll do a much better job. So I'll let you introduce yourself.
Thanks very much, Leslie Ann. It's really nice to be a part of this event today, and I appreciate the invitation. So, I am the Executive Director and General Counsel of the Women's Legal Education and Action Fund, also known as LEAF. We do litigation, law reform, and public legal education to advance gender equality across Canada. I am joining you today from Toronto, or Takarata, which is the traditional territory of, among others, the Anishinaabe, the Wendat, and the Haudenosaunee. It's governed by the Treaty 13 with the Mississaugas of the Credit, and it is also falling within the Dish with One Spoon Wampum Belt Covenant, which obliges us or encourages us to share the land peaceably. So especially today, I want to acknowledge that and to turn my mind directly to the steps that I am taking in my personal and professional lives to advance reconciliation, to amplify Indigenous voices, ways of knowing, and legal orders as well. And I hope others who are part of this discussion today will also turn their minds to that too. Uh, Leslie Ann, should we launch into the first topic, or should I throw it back over to you for a bit more context?
No, I think I'm happy to launch in as just a couple other housekeeping with this. Pam is going to chat with us about interventions. And as a reminder, today, all funds raised are going to Raven's Intervenor Fund, which does allow nations to access funding to make strategic interventions. If you have any questions throughout, we will have some time at the end of Pam's presentation for questions. So feel free to pop them into the Q&A or into the chat, and we'll be sure to make time for as many as we can. So with that, I'll hand it over to you, Pam. Would you like Carissa to go ahead and pull up your slides?
That would be great, please.
Thank you.
I hope folks will feel that they are, comfortable asking any questions that they have. If we see things pop up in the chat during the course of the presentation, I'll try to address those as they go along. I know we've got an intimate group today, and it really, I think, provides an opportunity to ask questions and to maybe have discussions, at least through the chat, to address really the pressing issues that are on your mind. So you've got in front of you an agenda for my presentation. So I'm just going to talk a bit about LEAF. We're going to talk about what interventions are, considerations, whether they be substantive, procedural, or cost-related considerations when it comes to proposed interventions, and then some logistics of intervening, including some tricks and tips and things that if you or colleagues of yours as lawyers are thinking about wanting to act on an intervention or pitch an intervention, things that you should keep in mind. And then I'll also talk a little bit about, if there are folks from organizations themselves, things that they'll want to keep in mind as well when they're considering intervening in litigation. I'm also going to be turning on occasion to my screen over here where I have some notes that aren't appearing on the slides, so I don't want folks to think that I'm off sending emails, just to give that warning. We can go to the next slide. So as I mentioned, LEAF, national nonprofit and charity, we've existed since 1985. We use the law reform, public education to advance the rights of women, girls, trans, and non-binary people across Canada. And over the course of our almost 40-year history, we've been part of a lot of really exciting gains. Some of them used litigation to achieve them, especially since the advent of the Charter and the equality rights provision under Section 15. And so the organization that I have the privilege of leading has a really extensive history in intervening in cases. And that includes first instance cases, provincial appellate courts, the Federal Court of Appeal, and the Supreme Court of Canada, which is where we've appeared most frequently over the course of our history. So with that background, you can move to the next slide and talk a little bit about what interventions are, who does them, and why. So first, talking a little bit about what is an intervention for folks who might not know. There are different kinds of interventions that you can undertake as an organization or as an intervener. Is one being party intervener status, and that the primary thing to keep in mind about that is that when you have party intervener status, you often have or seek the right to adduce evidence. That's going to be very unusual at anywhere other than a first instance proceeding, and generally courts are not as amenable to interveners coming in and deducing evidence. So you see that a lot less frequently than the more common friend of the court intervener. So what happens when you are intervening as a friend of the court is that you present written and oral submissions about an issue related to the case that are useful, distinct from those already being put forward by the parties. So for instance, LEAF often intervenes to provide perspectives on how the law should be interpreted and applied and developed in light of its impact on women, girls, trans and non-binary people. So when we consider whether or not to get involved in a case, we have that sort of lens in mind, and I'll talk a little bit about more of those considerations in a few minutes. Who intervenes? Very often it's not-for-profits and professional associations, the Canadian Bar Association being an example of one of those. Frequently we'll seek leave to intervene to bring the perspective of the bar to a case or considerations related to solicitor-client privilege, for example. The Advocacy Society also intervenes from time to time in court cases. Organizations that you'll see most frequently include organizations like LEAF, the Canadian Civil Liberties Association, the BC Civil Liberties Association, the Criminal Lawyers Association. Organizations that provide frontline services also will frequently seek leave to intervene in cases. The most prominent example in my line of work, at least, is the Barbara Schleifer Commemorative Clinic, which is an organization here in Toronto that provides legal services, counseling services to women who are seeking to flee violence, and they provide immigration-related services as well. And they frequently seek leave to intervene in cases where matters of gender equality are brought forward. So those are some examples of who intervenes most frequently. So why would you want to intervene? Most often an organization will intervene because the case raises an issue related to its mandate. And they will have some expertise to bring to bear on that case and that issue that's being brought forward in the case. They'll have something useful to say to the court that otherwise wouldn't be brought to the court's attention if they were not to seek leave to intervene to make those presentations of arguments. So you'll want to consider intervening in case perhaps when you have something to say about the legal issues that are raised in it. So you have an interest perhaps in the development of the law as it relates to how it might impact clients that you serve, if you're a frontline service organization, or groups that you advocate for if you are, like LEAF, an advocacy or systemic change organization. And you'll also want to consider maybe bringing to bear or bringing to light impacts that the case and the development of the law in this area will have on individuals for whom you advocate as well. I think I'll invite you, Leslie Ann, of course, to, if there are things that I'm sort of talking about on the slides that you think it might be helpful to expand on or that raise questions for you, happy for you to interject or intervene to raise those questions along the way too.
Thank you, Pam. I definitely will.
So moving on to some of the substantive considerations in deciding to intervene. whether you are an organization or a member of an organization, or whether you're a lawyer who has a client or wants to pitch an intervention to a prospective client, you're going to want to consider the relationship between the issue that is being raised in the case and the organization's mandate. So again, if you're looking at an organization that perhaps serves or advocates for a specific population that'll be impacted by the case, you'll also want to consider whether the organization has existing expertise in the subject matter of the case, not necessarily existing expertise in interventions themselves. You'll also want to consider having that useful and unique argument to advance. The point of an intervention, like I said, is to bring a unique and useful perspective that wouldn't otherwise be brought forward in that case, that is relevant to the outcome of that case. You want to ensure you're not duplicating what the parties are already proposing, because the court will say that's not helpful, we're not going to hear from you here. You're going to want to consider what's the value add, what would be missing from this case that would not be there if we didn't bring that perspective or that argument forward. And I emphasize those issues because there has, over the past couple of years, been a real trend, I think, in the Supreme Court's jurisprudence, as well as the jurisprudence of some other courts, I'll say notably the Federal Court and the Federal Court of Appeal, to be very particular about ensuring that this requirement of a useful and unique argument and perspective is met in cases. So one case that I'll flag that is interesting in this regard is a case called Klubakov, which the Supreme Court will be hearing soon. It is in part a challenge to the constitutionality, or I should say as a challenge to the constitutionality of part of the criminal code related to the criminalization of sex work. And a couple of weeks ago, Justice Rowe released a decision on several intervenor applications in that case and provided some reasons, which is unusual. Usually you don't get reasons at the Supreme Court for why leave to intervene has been denied. But there were a number of explanations about the duplication of arguments being a basis for why the court wouldn't grant leave to intervene. And also at the same time, this is the fun sort of balancing act that we get to do when we're thinking about intervening, not expanding the issues that are being put forward by the parties in the case. So the Klubakov example, there were also leave applications denied for intervention status on the basis that new issues were being raised as well. So when you and your client are considering intervening in a case, you're going to want to have those two substantive things front of mind: something unique, useful, different than what the parties are arguing, while not expanding the issue set before the court, which has been defined by the parties. The Supreme Court jurisprudence, for those who are interested, has been infiltrating lower courts, or I should say influencing lower courts' consideration of intervention applications as well. There are a couple of decisions that speak to that. One is Sharma, where there were comments made on the nature of interveners' roles in cases that would be very useful to refer to if you're considering pitching an intervention or developing an intervention at all. And the McGregor is the second case, which has additional comments, particularly from Justice Rowe in a decision that was written on his own, but that has been sort of taken up in other courts and other approaches to the jurisprudence. There's also a November 2021 directive from the Supreme Court that talks about the expectations of interveners. And I won't sort of repeat those, but for folks who are interested in this, you're going to want to make note of that and sort of have those guidelines in mind when you are thinking about intervening or pitching an intervention to a client. So moving along to some of the procedural considerations in deciding to intervene, and a
Pam,
flag
I'm
to
actually,
certainly.
I was just going to add that unique perspective. One of the ways we tend to see nations we work with approach that unique perspective is it is a really great opportunity for nations to bring in their knowledge about treaty interpretations and the history there to ensure interpretations are done well. It can sometimes be an opportunity for Indigenous nations to bring their legal orders into the court as well. And so sometimes that unique perspective can also be bringing in those opportunities to push the court a little bit further on recognizing Indigenous legal orders and perspective as well, with the caveat of doing it carefully with all of the restraints that Pam has already mentioned as well. That's one we see in our work, and one I imagine folks will be interested in continuing to hear as well through our work. But it's also something that I think is really exciting because it provides an opportunity for organizations like Leaf, Pam, to also be bringing that in, whether it be Indigenous laws around gender discrimination or domestic violence, and finding opportunities to do some of that intersectional and work and cross mandate work, which is really exciting.
You're absolutely right, Leslie. So procedural considerations in deciding to intervene. So focusing on the level of court first. There are different rules that apply, notwithstanding the sort of influence of the Supreme Court's recent jurisprudence and approach to interveners. You'll want to be familiar with the rules for that specific court and their jurisprudence on tests for leave to intervene. So, for example, at the federal court and federal court of appeal, the jurisprudence that has developed under the intervention rules is quite strict. And so when you're thinking about whether or not to pitch an intervention and how to frame that, you're really going to want to turn your mind to that jurisprudence and those rules that exist in the different courts. There's also different potential impacts. Oh, sorry, before I move on, but the different rules or lack thereof. One of the challenges, I think, with the federal court as well, not to spend too much time picking on the courts, but there's no timeline for when interventions are to be submitted. So, for example, if you're dealing with a judicial review application to the federal court or federal court of appeal in which you might want to intervene, those cases and judicial reviews are meant to be expeditious. They're meant to be done in a very timely way, and it's hard to pick when you are going to choose to submit a motion for leave to intervene without disrupting the cadence of the case, but while also having enough time to understand what the arguments are going to be brought forward by the parties so that you're not duplicating them. I've sometimes felt it's like there's an old saying about or maybe it's not old, but the saying about avocados and their ripeness and the approach being not yet, not yet, not yet, too late. So there's the split second in there sometimes with some of these interventions, finding the timing that is right, that allows you to propose useful arguments while also not risking delaying the proceeding, which is going to be a consideration in many cases as well. So the different potential impact that you want to take into consideration. What I mean by that is that, of course, at a trial court, the decision would be of less persuasive value or binding value, of course, if you consider that can be appealed up to the Ontario Court of Appeal here in Ontario, for example, and then to the Supreme Court. So you want to consider the level of court you're intervening at and the impact that you could have in the case. On the flip side, if you were going to seek leave to intervene to help supplement the record or otherwise introduce new evidence, that you want to do at the first instance, whether it's a superior court or a federal court, or even considering intervening at a tribunal when the record is set. So depending on the kind of intervention you want to pursue, the kind of impact that you want to have, where you want to strategically put the organization's resources and focus, you want to consider the sort of outcome that you are realistically looking at, the impact that you could have at the different level of court. The timelines of litigation, I had myself a little bit with the talking about the judicial review, but that's one specific example that I wanted to flag as a procedural consideration. You're also going to want to just know about the specific rules, especially at the Supreme Court. They're very clear about when intervention applications are due, which is wonderfully helpful for an organization that is frequently doing this kind of intervention work. There's no sort of guessing or proposing one's own timetable. But as you're thinking about what the timelines are, I'll talk a little bit more in a few minutes about practical tips for considering intervening, but you're going to want to, as a professional courtesy, as well as a service to your own client, you're going to want to be in touch with the parties for the counsel for the parties in the litigation, if it's not at the Supreme Court, to understand the timeline on which they are moving along as well, so that you don't surprise anyone by showing up and saying you have an intervention application and the hearing's already been set down for 2 weeks later. Your intervention application is going to probably be dismissed because it would interrupt the timelines of the litigation. So it's important to have a good understanding of what those timelines are when you can fit in an application for leave to intervene, or whether it's not going to be possible in the circumstances of that case if the timetable has already been set in stone, more or less. So those are some of the procedural considerations. Some of the organizational considerations, and most often, of course, we see it's organizations that intervene in cases as opposed to individuals. So though there are exceptions to that, there is one in the Klubikov case, for example. So I commend reading that. I commend reading that decision on the intervention applications in that case. The capacity of the organization is going to be important, of course. Many of the organizations, especially those who, especially nations, Indigenous-led organizations, they're going to be often, I think, stretched for resources. And if they don't have the ability to take on the sort of intervention that you might want to pitch to them, whether they're an existing client or a prospective client, that's going to be an issue to consider. The cost is also going to be something of consideration for any kind of organization, nonprofit, nation that is considering intervening. We know that a lot of interventions are done pro bono. I say the overwhelming majority of interventions are done pro bono. Sitting where I sit at LEAF, I'm very conscious of the impact that has on small firms, members of small firms or sole practitioners, and especially folks in marginalized communities, to be asked to do a whole bunch of free work on top of already having a really challenging practice space that they occupy. So if you are considering intervening and you have the capacity and willingness to take on a case pro bono, that's wonderful. Organizations will be very happy to hear that, but there are funding opportunities available to apply to in order to fund this important work, because interventions have such an important role to play in the development of the law. And so maybe this is a good point to sort of turn it over to Leslie Ann to talk a little bit about the Ignite Intervention Fund.
Thank you, Pam. So as many folks know, Raven does have an Intervenor Fund, which allows Indigenous nations, Indigenous organizations that fit within our mandate of work that focuses on protecting rights and territory to apply for support for an intervention. We can provide up to $20,000, which for most interventions is a pretty substantial amount. And like other work Raven does, nations can apply to us. They still choose their own lawyer. We are not here to dictate your intervention. We're not here to dictate your solicitor-client relationship. And so it's a great opportunity for both nations who might be interested in an issue, maybe don't have a lawyer yet, but want to secure that funding, to then be able to go pitch to a lawyer. Or if you're a lawyer who works with Indigenous nations and sees something happening that you think will affect your clients might be interested in intervening on, you can propose accessing our Intervenor Fund is a way to do that without putting an additional burden on your client. Because unfortunately, that's part of the reality of interventions is we require interventions, as Pam is saying, to develop the law in a good and helpful and useful way. And yet we're inherently asking organizations who aren't a party to the dispute to come in out of the goodness of their heart or a little bit of self-preservation at times to direct their resources to this legal issue. And it's an incredible burden that our legal system puts on us to do that work in order to help develop the law in a good way. And so this is one opportunity that does exist to lift some of that burden, whether it be for nations who want to then seek a lawyer to assist them with this, or a lawyer who's seeing this issue for their clients, their Indigenous clients, and wants to say there is a way we can go do this and we can address this issue. It's, as anyone who knows me knows, I have a lot of little pet peeves about our legal system. And there's a reason I don't call it a justice system. And this is absolutely one of them. Pam, I'll hand it back over to you to talk about the Court Challenges program.
Thank you. So another source of funding is the Court Challenges program, through which up to $45,000 is available, $10,000 to fund an application for leave to intervene, and up to $35,000 to fund work on the intervention itself if leave to intervene is granted. If you Google Court Challenges program, you'll come up with both the human rights stream and the official languages stream. We, as LEAF, we apply to the human rights stream, given the work that we do and the interventions that we've been part of or proposed to be part of over the last number of years. There's it's a bit of an intensive application process, but you're able to apply for funding where you are part of, where the case is challenging a federal law on the basis of enumerated charter rights, human rights under the charter. So that is a useful source of funding. It does have a history, the program does have a history of having been eradicated under the previous government, reinstated under the current government, and well-funded. And it is, I think, fair to say that should there be a change in government, there would be the future of the program, I think, would be a little bit uncertain, but it is a really wonderful resource to have for all the reasons that Leslie Ann has already said. It's important to have funding available to interventions. Parenthetically, there's also funding available to develop test cases to challenge those same kinds of laws, the federal laws. So it might be something there for folks to explore if you want to go that route. We're focusing on interventions today, but if you want to go full-fledged, be the plaintiff, be the applicant in a charter challenge, there is funding there to explore that as well. So in terms of risks or opportunities to the organization, by and large, when you're considering intervening as a friend of the court in particular, the risks are quite low if you're intervening on an issue that's related to your mandate, where you have something important and useful to say to the court that's going to help them get this issue right, get their heads around this issue, get this decision right. There are fairly low risks in my view. There are on occasion orders that will come from the Supreme Court that say the intervener, once they've been granted leave to intervene, is going to be responsible for any additional disbursements that are incurred by either of the parties related to the intervention. In my experience, we have yet to be presented with a bill of costs or a requirement to pay any costs as an intervener at the Supreme Court. And I would be quite frankly surprised if that practice and that reality changed. But beyond those sort of minimal disbursements that might be contemplated in some of the intervention orders, interventions are done on no costs basis. So when you develop your materials, you submit your motion for leave to intervene, you make clear that you're not seeking costs, and you ask that no costs be ordered against you either. Opportunities. There are some really wonderful opportunities, not just related to the development of the law, which is an incredibly important one, but also related to engaging in advocacy around the issue outside of the court. So to provide a concrete example, we have sought leave to intervene and been granted intervention status in challenges to sort of colloquially call pronoun policies in Saskatchewan and New Brunswick, which effectively strip the right of trans youth to choose to be identified by their proper pronouns and their proper names, as opposed to the names and pronouns that might appear on their birth certificate. Requirements of forced outing in the case of Saskatchewan, if that sort of desire to be referred to in a certain way is disclosed to folks in the school system, so forced outing to parents, very deeply problematic and, in our view, charter violating provisions and laws. So while we have been granted intervenor status in both of those challenges, we are focusing on the law and not taking a discrete and clear position on the outcome of the case. It is improper, in my view, and also in accordance with the guidance of the Supreme Court, to take positions as an intervener on the disposition of a case, and you will find courts bristling if you propose to do that in an intervention. But that doesn't mean we can't, outside of the context of those legal submissions, take very clear positions on whether or not a certain law is unconstitutional or deeply offensive and ought to be struck down. So we can parlay those interventions, as we have, into broader advocacy socially to our members, to the broader public, to bring awareness to the problems and the ways in which these laws violate the rights of the youth that are being targeted. In that same way, whatever case that you are considering pitching for an intervention, or a case that an organization is going to be intervening in, it's, I think, very worthwhile, depending on capacity and the desire of the organization, to consider what other advocacy can you do to advance the interests of the organization and its position on those particular issues outside of the court. Op-eds, communications to members, communications to the broader public, advocacy for law reform if appropriate. Many of these things can be tied in as opportunities to also work on the same issues that are coming up in the court case. So those are some, I think, really great considerations to keep in mind for organizations that are thinking about seeking leave to intervene in a case as well. So I'll conclude with some tips if you want to act on an intervention. Keep your eyes open for interesting cases that raise issues that are of interest, whether it's to you personally, to the organization that you might volunteer with, to an organization that you might know of, or if you are leading the organization, to the organization itself. You want to think about what the potential submissions, what's the value add that that organization could bring through an intervention. And you want to be prepared to talk about that when you approach the client or the prospective client to talk about the intervention. You want to, especially if there hasn't been history of intervening in cases, you want to be prepared to explain at a practical level to fulfill your obligations as a lawyer to your client, explaining what exactly it is that an intervention is, what the considerations are, some of the things that I've talked about a bit in this presentation, the kind of support the organization would need, and the capacity that they should think about creating, or whether they have the capacity to be able to do the intervention, and to provide instructions in a thoughtful way. You're going to want to, as I mentioned earlier, approach the lawyers or the party, at least as a starting point, the party that is most aligned in interest with your client. The way I like to think about interventions, again, is you're coming in, you're not supposed to be putting explicitly your finger on the scale on one side or the other, but just because, as the Supreme Court's November 2021 directive acknowledges, just because your position aligns with one party more than another does not make it improper. You're going to find in most cases that there's one party or another with which your interest aligns. It is a professional courtesy as well as a very useful thing to do at a practical level to reach out to counsel for that party to say, "Hi, I am Pam. I am thinking or helping my organization, helping whether it's Leaf or the organization that you've approached, and helping them think about whether or not seeking leave to intervene in this case would be a useful thing for them to do. Can you tell me a bit about the arguments that you're pursuing on appeal? If you're able to do that, are you in a position to sort of tell me if bringing forward X and Y arguments might be a useful perspective for the court to hear? Can you tell me about the timeline of the case if it's not a Supreme Court intervention? These are friendly conversations that regularly happen between interveners who do a lot of work in this area, who do a lot of intervention work, as well as parties that are and counsel that are acting for parties on some of these higher profile cases. So highly recommend doing that, and it's not unusual. It's a good practice to do that. And then you're going to want to try to identify and coordinate with any other prospective interveners. This is also a helpful question to ask counsel for the party who's most aligned in interest. Are there other organizations that you've heard from already that are interested in intervening? Have you approached other parties? What do you know about the landscape that you're able to share? Sometimes you'll find that if, for example, 3 or 4 other gender equality organizations, if I find, for example, 3 or 4 gender equality organizations are already in the process of developing intervention applications, maybe Leaf's voice doesn't need to be heard in this case. And maybe it is better for the development of the law more broadly and in different areas to have Leaf's resources for that would have been devoted to that particular case, devoted to a different case instead. So we ensure that there are those perspectives that are important for a gender equality lens brought to bear in as many cases as possible. So that coordination piece is important too. And you're going to want to consider when you're developing your application materials, we do it as a common practice, being clear that we will coordinate with parties and we will coordinate with other prospective interveners to avoid duplication of arguments and ensure that we're providing something useful and different to the court, and that in as many cases as possible, we can say we have already done that to date. So that's going to be helpful for ensuring that you have that useful and distinct perspective, that you are being a good professional colleague, and that you're also ensuring that resources are being allocated, resources that are scarce are being allocated in the most effective way possible to advance the sort of interests that you're passionate about and the organization that you're seeking to represent and an intervention is passionate about as well. Those are my tips. Leslie Ann?
Thank you so much, Pam. That was incredibly helpful. A lot of really great information. We will open it up to questions, and I have a couple already to start with, one of which actually dovetails really well with the last point you were making. We tend now often to be seeing a lot of coalitions of organizations seeking leave collectively. And again, I am a much more junior lawyer than you are, but to me, this seems to be a bit of a newer trend, seeing it to the amount we're seeing it. I might be wrong. But I'm wondering if you can speak to, why we're seeing so many coalitions, why that's valuable, and when to consider approaching things as a coalition or a group rather than multiple organizations intervening.
That's a great question. So to first deal with the potential trend of seeing increased coalitions, I'm not entirely sure that that's the case. I think if you look back at some of the big early charter challenges, you see big intervention coalitions. I think there were fairly big ones in Seaboyer and Canadian newspapers. This just sort of happens from time to time. I'm not sure, at least at the Supreme Court, level that we're necessarily seeing more coalitions of interveners. In fact, when considering whether or not to intervene in coalition at the Supreme Court, one of the considerations is you only get 10 pages to make an argument and 5 minutes of oral submissions if you are granted leave to intervene. So I have certainly been part of discussions where organizations that might otherwise think about intervening in coalition actually say, well, there are about 3 different points that we want to make between the 3 organizations that might otherwise intervene in coalition. It makes more sense for us to break off and each focus on one of these discrete points so that we can address it in a meaningful way in those 10 pages in 5 minutes. When you might want to consider, I think, intervening in coalition would be when you get together and sort of think, all right, well, we kind of want to make the same arguments. And there's a decision point about, do we decide to just, for one of us to go it alone and the other organization to put its resources into another case, for example, or do we decide, no, this is important to both of our organizations. We both have interesting perspectives and important perspectives. We want to perhaps share the burden of the work that has to be done to intervene in a case. And so we decide to jointly intervene. Those are the kinds of conversations that have happened, I think, and are important to happen in a sort of healthy, productive, relationship building way among organizations, especially as they frequently intervene in cases. So those are some of the considerations that come to bear, I think, in the questions that you're asking.
That's really helpful. Thank you. Another question that came up is, you've mentioned some of the considerations when considering intervening at different levels of court, around the timelines of the Supreme Court, as well as I don't want to say value because there's value in any intervention, but of course, a Supreme Court decision has a larger impact than others. Are there other considerations you think about when deciding to get involved? For example, do you consider the success rate of an intervention application? We all know that not every decision that seeks leave to the Supreme Court is going to get it to begin with. Do you consider the cost of, an intervention in Ottawa versus a more local intervention? What are some of the other things you might consider or organizations should consider?
Yeah, those are really good questions, and those are considerations as well. Like, what is the likelihood of success? You can't predict in many of these cases. I mean, to come back to the federal court again, you can probably predict it fairly accurately whether or not you'll be granted leave to intervene, because many organizations are simply denied leave to intervene at the federal court and federal court of appeal, including, and I say this cheekily because I do have a lot of fondness for the federal court of appeal, having spent a bit of time working there. But in the recent constitutional challenge to the Safe Third Countries Agreement, I think every intervener was denied leave to intervene at the federal court of appeal, and then pretty much all but I think 3 organizations who applied for leave to intervene at the Supreme Court were granted leave. It's a much more, you're much more likely statistically to be successful seeking leave to intervene at the Supreme Court than you are at the federal court and federal court of appeal. So I think it is a fair consideration. If you're looking at whether it's the nature of the rules and the jurisprudence that exists, and that's why I think it's important to have a sense of that when you're advising a client or pitching a client on this. Do you have a reasonable prospect of success in light of the rules that apply and the considerations that apply to various courts' consideration of applications for leave to intervene? You also, in that same sort of sense, the likelihood of success, to the extent that you can predict it, will also be influenced by, have you got that unique perspective? So if you don't have the unique perspective, or you're duplicating parties, you're duplicating other interveners, chances are you're not going to get leave to intervene, and that your resources could be better placed elsewhere for an organization. As for the sort of costs, local versus Ottawa, right now, all interveners at the Supreme Court are required to appear remotely. So there's not in the pre-COVID days, you would go in person. There was no remote option, and so that was a legitimate consideration. Does the organization, or does the lawyer who's representing the organization, want to take on the costs of flying somebody to Ottawa from wherever they are otherwise located in the country? And that is that would be a significant disbursement to some organizations or prospective interveners. Today, that's not as much of a consideration because of that remote requirement to appear remotely for interveners at the Supreme Court. But there would be, I think, similar concerns that you want to take into account if, for example, you were a lawyer in Northern Ontario and arguing or proposing to intervene in a case that's being heard at the Court of Appeal for Ontario if they do not have a remote appearance option. Absolutely take those considerations into account in terms of the costs of the case as well.
It's really helpful. Thank you. And another question was, this is my own question, actually, quite frankly. You mentioned Klubakov, which, if I remember correctly, was also one where a organization of sex workers was denied their intervention application. And I've seen some organizations turn that actually into their own opportunity for advocacy. Do you have advice, or not necessarily advice, but suggestions, tips, things to consider for if you are denied your leave to intervene, what you can do with that to still engage in that advocacy we're hoping to do?
Yeah, yes. So there was the Canadian Alliance for Sex Work Law Reform, which is a party in its own application challenging the entire criminal code scheme related to sex work, was denied leave to intervene in Klubakov. That partial challenge, or that challenge to part of the laws related to the criminalization of sex work, which was really disappointing and in certain respects quite flummoxing. It would be, I think, important to hear the perspective of sex workers in a case that deals with the criminalization of the work that they do. So yes, you've seen that the organization advocate publicly against that decision, and that is certainly one thing that can be done if you're denied leave to intervene. I think a really interesting other thing that can be done in some circumstances, at least, is considering whether there might be law reform advocacy stemming from the work that has already been done to prepare an intervention brief. So if there is a constitutional challenge to a law especially at an intermediate appellate court or a first instance court, if you're denied leave to intervene, or if you were granted leave to intervene, these things can work in parallel. But I would say not all is lost. There is some work you might find that can be taken from the intervention that was prepared to be pitched and maybe rolled into an advocacy brief to parliamentarians, to others with decision-making authority, to say, here are the reasons why you should actually just get ahead of this and change this law. Whether or not you will get uptake is a different question. I think one of politicians' favorite lines in response to a pitch like that might be, it's before the courts. Let the courts deal with it, that sort of thing. But it doesn't take away, I think, the importance that can the importance and potential effectiveness, at least, of educating decision makers, educating some of the people who have interests in your organization or are served by your organization, so that they understand why this is a problem, and use it as an opportunity to sort of engage in some of that community building, relationship building, advocacy, not just letting the proposed intervention kind of languish because the door was shut in that case.
That's really helpful. Thank you. And that was the last of the questions we had. And so, Pam, I'll ask you, did you have anything else that you wanted to say? Any last thoughts you wanted to share?
No, I mean, I guess maybe the last thing I'll say is, it's for the group of folks who are here today, if there are other, if you ever want to be in touch and you have questions about interventions, I'm more than happy to talk, and I'm very easy to find on the internet. So please don't hesitate to reach out.
Thank you, Pam. And one last question for you, just because it is also Pride Month, and I know Leaf has been doing quite a bit of work around not around shifting their focus from not just focused on women, but also including within the work you do, trans and non-binary folks. Is there anything coming up with Leaf on that realm of things that you wanted to mention for folks here today to check out? I am just bringing this on you, so it's okay if you don't have anything immediately
No,
in
it's
mind.
no, it's okay. The thing that comes to mind most immediately, I've already mentioned, is the our intervention work in those two cases in New Brunswick and Saskatchewan, and we've also been doing some. We did some advocacy, really trying to coordinate and um, convene the voices of feminist organizations in whose name, in women's name and cis women's name, so often trans exclusionary policies are proposed or adopted. You think of trans women in sport. We must do this, we must exclude them to protect cis women. And so it is so important for organizations that have historically served cis women and perhaps have become more trans inclusive as we have, to stand up and say, not basically not in our name. So you'll find, if you go to our website, you Google Leaf and trans inclusion, you'll see both information about the interventions that we're doing, as well as the non-law related advocacy that we are doing to really try and be in solidarity with trans folks in the face of rising anti-trans hatred.
No, thank you so much for that. And I do see Levin has shared a little bit of that, a link from your website for folks who are interested, which is great. Thank you so much, Levin. And thank you so much again, Pam, for joining us today. We really appreciate it. And I look forward to getting to continue to work with you.
I feel the same way. Thank you so much for having me today.
Thank you. Thank you so much for joining us. And I'm really excited for our discussion this morning about working with Indigenous clients and why it can be different, why it matters, what to consider, and things like that. As a note to attendees, we will be sending out a follow-up email after today with not only the recording, but also with a few resources, including some that the panelists might mention as we go through, as at least one of them, Jonathan, was involved in the development of, and so he may choose to reference it. Before we get right into it, let's do some introductions. Akosua, would you like to start?
Sure. So thank you so much, Leslie Ann, for the invitation. And Jonathan, it's great to see you again. So I'm Akosua Matthews, and I'm a senior associate at Kastner Ko, and I practice what's called state accountability law, which means I advance civil claims against police forces in particular, and sometimes a corresponding coroner's inquest. I also have advanced human rights claims, the largest being the Canadian Human Rights Tribunal case on Indigenous child welfare, where I represented Anishinaabe Aski Nation. I also have a growing workplace investigation practice. So I will be referencing these areas of my practice in today's presentation.
Thank you so much. And great to hear that your workplace investigation practice is growing. I know there is very much a desire for folks who are competent in working with Indigenous communities in that realm of work. And Jonathan.
Hi, everyone. Hi, Leslie Ann. Hi, Akosua. It's good to see you both. So I'm currently the Special Projects Director at Aboriginal Legal Services. I've been with Aboriginal Legal Services since it started in 1990. Probably most relevant to this work is I've worked with and supervised our court workers and some of our lawyers working with Indigenous people involved in the courts, developing GLADU reports, along with Krista Big Canoe. I was co-counsel for the 7 families in the 7 First Nations Youth Inquest in Thunder Bay, and the interminable and awful follow-up that's stemmed from that. Yeah, so I've just been doing this for a long time. That's basically it.
Thank you, Jonathan. And so when we had a bit of a pre-conversation to chat about this work, about this panel, one of the things we talked about was issues that arise right from the beginning of the solicitor-client relationship, and how building that relationship is incredibly important in being able to serve your client. Can you two both speak to that a little bit? I see you nodding, Akosua, so I don't know if you want to start.
Sure. Well, I had the great honor of starting my practice in law, serving Anishinaabe Nation, which is a political territorial organization that represents 49 First Nations in the remote northwestern part of Ontario. And so this was quite an education in, I think, what is needed to serve Indigenous communities, and in particular, remote Indigenous communities. And I think the biggest factor that I learned right off the hop was just time. You need so much time to, first of all, traverse to Northwestern Ontario. It's the same distance as going to Florida, and it's not as direct. You will likely have to take multiple planes, and there could be a very treacherous ice road along the way. And when you get there, there will be protocols about community visitation and who you meet with first, chief and counsel, and other members of the community. And all of that requires time. And second to that, I think humility. And I don't know that either of these two qualities, or necessary qualities, are things that are taught in law school, but they're absolutely essential to serving Indigenous communities and Indigenous people. And if you aren't willing to put the time in and adopt a humble approach to the practice of law and a gentle approach, I don't think you're really well served in this area and in this space. So along with that, the importance of geography and being in person, it is really hard to serve community if you've never been to that community, or you don't know the key leaders in that community. This becomes more complicated if you're representing a First Nation or an Indigenous organization. You will then have to understand how that organization is structured, both in a corporate sense, but in most particularly a political sense. And you'll have to understand its relationship to other First Nations governments. So this stuff takes time. It takes years of practice to learn and absorb. And it requires being present in location and often taking a back seat and becoming more of an observer in order to better serve Indigenous people, organizations, and First Nations.
Thank you. And I think you're right. It's not things law school teaches. Law school does not teach you to leave time, to leave space, to be humble, to not act as the expert in the room. Jonathan?
Yeah, so I agree with everything Akosua said, and especially time. Let me take it from a slightly different perspective, because I think it's very important what was talked about in terms of working with Indigenous nations and people in Indigenous nations. Many lawyers are working with clients who come into their office and they don't know anything about that person. And they don't know if the person is Indigenous. They don't know if the person isn't Indigenous. And many lawyers rely on their innate ability to determine who is Indigenous and who isn't, and they're pathetic at it, which they would be because Indigenous people come in all shapes, sizes, colors, and everything. So the challenge that you have if you don't know from the outset that your client is an Indigenous person is, and we'll go into more of this later, but as your case comes up, you may discover right near the end that there are a whole bunch of things that you should have known about that you didn't. So one of the first thing you have to do, you have to ask the client if they are Indigenous. And you can't assume that people aren't Indigenous. But you also can't just say, hey, are you Indigenous? Are you an Indian? Are you like you have to think about the question that you're asking. And the first thing you have to think about is, why are you asking the question? Because think about it from the perspective of the person being asked. Why do you want to know this? Why is this at all relevant? Why do I need to share this with you? Especially when you think that for Indigenous people, being identified as Indigenous as you go through the court system has never been an advantage. Like if you can get through not putting your hand up, then that's a good strategy. So it's really important that when you ask the question, that you explain first why you want to know. So, if it's a criminal case, I can be representing this criminal case. There are specific provisions relating to bail, to trial, to sentencing that matter if someone's Indigenous. So I need to know if you're an Indigenous person before we start. So you need to explain that. And then you have to think about the word Indigenous. The word Indigenous is not a word that Indigenous people generally use to describe themselves because it is a term that is used externally to define a broad group of people who each have their own identities. So you have to say, Indigenous, Aboriginal, Native, Indian, like whatever, and that includes First Nation status, non-status, Inuit, Métis. I see a lot of lawyers say, are you a First Nations person? Thinking First Nations is a synonym for all Indigenous people. And in fact, it isn't. So if you have an Inuit client, if you have a Métis person, if you ask them, are they First Nations? The answer is no. So that's just right off the top. You have to find a way to ask the question. You have to ask the question, and you need to take time to do that. And the last thing I'll say about this, because we could spend the whole session just on this, the other thing that I think is really important, and this speaks to the humility question, is then you should ask the client how they would like to be described, right? Like, what do they prefer? I know some people who hate the word Indigenous, like they hate the word Indigenous, and they would rather be called an Indian than Indigenous. Well, that's fine. It's not their problem. They are entitled to call themselves what they want. People may want to describe themselves in terms of their tribal affiliation. So you want to know that so you can provide that information for the court. So I'll stop it there before I keep going on and on and on.
Thank you, Jonathan. And I think actually some of what you talked about provides a good segue. You talked a little bit about in the criminal court system why it matters if your client is Indigenous, but we know that's also not the only time. Would you either of you like to talk a little bit more about why that actually matters and when it can matter outside of the criminal system as well?
Yeah, I think I can pick up on that perhaps in the coroner system. So in this case, you may not have a direct relationship with a client that's Indigenous, but the issue of indigeneity is very much at issue. So it could be with respect to the deceased, in which case you better hope that the scope includes that as an issue. And that the parties that appear at the coroner's inquest have some relationship to that. So not only the family, but Indigenous organizations. And, I think about things like the Brian Sinclair inquest in Manitoba, where racism was explicitly scoped out. So that's an example where the system sort of excludes these issues that are absolutely relevant. And I think you would have to, as counsel involved in a coroner's inquest, be alive to that and look for evidence of it in the coroner's brief, because it may well be that it has escaped coroner's counsel that the deceased was Indigenous, right? And so, although that's not your client, I think it behooves all counsel to raise that because it impacts scope, it impacts potentially jury representation, it impacts the recommendations that come out of a coroner system. So I think you need, to Jonathan's point, you need to understand what the barriers are systematically to even be able to issue spot appropriately, whether or not it is something that arises in a direct solicitor-client relationship. And then I think the other thing is it comes up in terms of access to systems. The coroner system in particular has now moved to a default presumption of being online. And that can materially prevent some Indigenous communities or people from participating in an inquest. And so that's something you need to be aware of. Where are people located, and how will they actually participate? And what are the default assumptions for that particular forum? So I think that's very much a live issue in the coroner system, and it's something that people who participate in it need to be aware of.
So I would add, I think those are all really important. I mean, there are many aspects of law have Indigenous specific elements that you need to be aware of. If you do wills and estates, there are special rules about the distribution of property on reserve. So you need to know where the client's property is located, and they could give a name, but if you don't look it up or ask more questions, you may not know that the property is located on reserve. There are provisions around division of family property in divorce cases or separation that has an impact if someone has property on the First Nation. You want to know that even if people don't have property on the First Nation, because the person might think that some of these rules apply to them when they don't. You also want to think about what we broadly call the Gladue principles, which is sort of this approach to what was originally criminal law, but how that's expanded to other areas of law. For example, we've done professional discipline cases for lawyers, Indigenous lawyers. There's special considerations. The Law Society has agreed and recognizes the Gladue considerations apply in professional discipline. Well, you need to know that your client's Indigenous. We just recently received a decision from the Landlord-Tenant Board around, what are they going to do with someone who breached the quiet enjoyment of someone's of the apartment. They consider Gladue in that context. So there are multitudes of ways in contracts. Are you negotiating with the First Nation? What does that mean? Where's I mean, it's just all sorts of areas. I'm not saying this to scare people away, but to suggest first that you need to know this information to do the work properly. And then once you get that information, getting back to time, you're going to have to take the time to learn, and also to understand that we didn't even get into child welfare. So like child welfare, there are a whole series of things that really matters. But as well, you need to understand that just because you may have worked with one Indigenous person in relation to one First Nation doesn't mean that all First Nations will be the same. Some First Nations have rules about matrimonial property, some don't. Some have their own child welfare rules, some don't. So you have to be alive to these things, and you can't be alive to these things if you don't know if your client is an Indigenous person to start with.
Thank you for that. And I think you're right, Jonathan. It's not to scare people. What I always think about is if you can learn the different court filing rules for Brampton, for Ottawa, for Toronto, the different expectations that each courthouse has, and you can file your work, you can figure out the different rules for separation of property on reserve. You can figure out the different rules for business operating on reserve or things like that. Similarly, in workplace investigations, I often think about, investigators who will just take an answer and not think to dig into it. And I reflect back on an investigation I did or I was part of. I wasn't the investigator in that matter, but someone mentioned an IHB health insurance, and the investigator didn't think to follow up on what that was, and didn't realize that by discussing an IHB, that person was essentially identifying themselves as Indigenous, having access through that. And so it is so many little things that you do have to ask the questions. You have to be patient. You have to be humble and deferential to a degree, but it's not so much that lawyers can't learn.
There's another example of that, actually, Lucian, that it's a case out of British Columbia called Camille. It's a criminal case. And anyway, it's a question of voluntariness of statement. And you read the decision, and the individual confesses. The question is, when police custody, is it voluntary? And as you read the summary, it says that at one point he received a large settlement from the Indian residential schools, and that's all it says. And no one, and I wasn't there obviously for the whole case, but if you know that your client has received a large settlement from the Indian residential school system, you know that they've suffered some really bad stuff. And you don't have to ask the client the bad stuff they suffered, because all you have to do is go to the colloquially referred to as the meat chart that was produced for residential schools, and you can see that if your client received $150,000, they suffered a lot of abuse. And you don't need to make your client's life awful by asking that, but you need to know that, and you need to be able to reflect that to the court. So similarly to the NIHB, there will be clues that are left for you, and if you are wanting to do this work, you need to be able to pick up those clues and do something useful with them.
Yeah, and even when the clues are there, and you're not in the exercise of divining indigeneity, and everyone understands that this is a live issue, you still have to ask a lot of questions. And I think of this in sort of the workplace investigation context. I get a lot of frantic calls from non-Indigenous organizations saying, we need an Indigenous investigator, but they don't often know why. And that's usually the first question that an investigator ought to ask. Why do you need an Indigenous investigator? Is it because there's some question about the background of the complainant or some person at that organization? Is it something that would just be helpful for me to know in terms of comfort and facilitating access to participation? Or is this somehow really central to the complaint? Such that I actually need to get expertise, external expertise, or talk to other people. And often the answer is they don't really know. They actually haven't done that kind of digging work, in which case it becomes your mandate to figure that out. And even so, I mean, I'm thinking of one investigation where I knew I was meeting with an Indigenous complainant. And I knew that the issue was eye contact in particular. The complainant didn't actually tie this issue to their own indigeneity. And so after, allowing the complainant to explain why a direction by a superior to look at them in the eye made them feel uncomfortable. The words described were like paternalistic, or it made me feel like my mother was admonishing me. There was never that sort of connection to Indigenous cultural practices. And so just to zoom out a bit, a lot of the conversational rules that we engage with are ultimately culturally informed. And eye contact is one that's not universal. In perhaps Toronto, downtown Toronto, if you're not maintaining eye contact, someone's going to think that that's suspicious, that you're trying to hide something, you're not being forthright. Well, in Cat Lake, Northwestern Ontario, it is what you do when someone is sharing their story. You do not make eye contact. You focus on the words, you look on the ground, and you focus on the story. And direct eye contact beyond sort of initial introductions could be viewed as quite rude and aggressive. So you need to know that. And to Jonathan's point, you need to know that that might not be a universal or pan-Indigenous practice. But in this workplace investigation context, it certainly required me to ask that pointed question. Look, I'm aware in having worked with Northwestern Ontario First Nations that this is a cultural practice. You wouldn't make eye contact, especially with a superior. Is that also the same for you? And the answer was yes. But had I not asked that question, it would not have been directly tied. And I think that's the thing. You can miss these things at really critical junctures that help define things like scope and ultimately impact the result of a lot of these kinds of processes. So even when you know what you have in front of you, be careful about just sort of sitting back and not allowing sort of limited answers to just sit as they are. You do have to engage. You do have to ask some follow-up after an appropriate amount of time to allow the person to tell their story.
Let me pick up on two of those things that Akosua said. They're really important. I got a call, I remember a number of years ago, from someone who said, we're trying to resolve a complaint with an Indigenous complainant. It was a workplace related issue, was going to some form of arbitration mediation. The person said, I know Indigenous people don't like to look people in the eye. And I said, well, wait a minute, like you don't assume that. You have to find out more. You can't work on that assumption, because if that's the assumption you work on, and then the person starts looking you directly in the eye, you're going to think they're not Indigenous or they don't respect you. Who knows what you're going to think? So a little knowledge is really just a little knowledge, which is not really sufficient. The other point that Akosua mentioned that you see a lot is someone says, oh, the person's Indigenous, as though that in and of itself is going to dictate the answer. And there are, as we've talked about, so many different Indigenous peoples. So I was just talking to one of our staff yesterday, where we do a program, a child welfare mediation program. We got this urgent call. We need someone. The client's Indigenous. Okay. And then they said the client's Indigenous, they're Anishinaabe. Well, they weren't. They were Inuit. And that's really different. And there are traditional and there are other cultural, there are whole differences, and you need to understand that. So it's not enough to know, I need an Indigenous person because your client's Indigenous. You may be, but maybe not. And maybe you need to be more specific. Maybe it isn't just an Indigenous person for an Indigenous person. You need to think about this in terms of clients whose first language is in English and who may prefer to speak another language. I need a Cree interpreter. Well, there are lots of varieties of Cree. That's not enough. I need an Inuktitut. There are varieties. You need to get more information, because again, if you don't, what happens is, and we've certainly seen this, I need a Cree interpreter. You get a Cree interpreter, but that Cree interpreter doesn't speak the same Cree. They don't necessarily say they don't speak the same Cree. And this whole case is going on, whether it's civil or whatever, and no one is necessarily getting the right information, although there will be people in the room going, that's not what they said. But if you don't speak Cree, you're not going to know that. So that's why you need to take all that extra time just to get to the bottom of these things.
And demonstrate humility in not knowing. Because I think what prevents people from asking the question is this sort of shame, which serves absolutely no one.
And it's such a fascinating shame to me, in the sense that most Indigenous folks don't expect you to actually know these things off the bat either. Yeah. And so it's not like you're surprising anyone. It's not like you're letting anybody down. Jonathan's laughing at me, but it's true.
Yeah.
It's doing exactly what would be expected. You both touched on a couple of things here that I think are really helpful for people to hear about. With, in particular, the example of eye contact and some of the common cultural practices or examples of just different ways of living, of being, of communicating that can be common to many of the Indigenous nations that you both see in your practices in Toronto, and I can say is common to as well as other parts of the country. Because this is something I struggled with a lot as an investigator, and even as a student learning about in crim, the idea of making credibility assessments based on interactions with somebody, when something like eye contact can be seen as being suspicious, not making eye contact, or being deceitful. And I know you both have talked about time, which can also be both in the sense of spending that time doing that work, but also giving people the opportunity for silence or pauses in speaking. Can you speak to a little bit about how you, in your practice, have seen these issues play out, or how you address them, and what are perhaps some of the common ones that folks should keep in mind in their practice areas across Canada?
So we were, as I said, I represented a number of the families from the First Nations Youth Inquest, and there have been subsequent investigations since, after the Independent Police Review Directorate found all the racism. Surprise, surprise, in the Thunder Bay Police Department. Anyway, there have been all these follow-ups. So, and eventually we had a meeting one day, we had a meeting with our clients, families in Sioux Lookout. And this was to meet with investigators to get information about subsequent investigations. So we met with all our clients. And so there were families and family members. And we started, it was the evening before, we had a circle. And we went around the circle. And, you know, one person spoke, the next person spoke. And so someone would speak. They were often, as Akosua said, they're all looking at the ground. And then they'd speak and they'd say some things. And then it would go like this. Now, I don't know how you're feeling. You may be feeling uncomfortable, but they would go like this. And then the person might start talking again. Or they might say, thank you, miigwech, I'm done. But that space, that silence is really important. And lawyers hate silence. Partly because everything's on the, for many people, things are on the clock. We're busy. We don't like silence. And so we interrupt. We say, okay, next. And you've lost what you've done when you do this. You've lost that moment. You've lost that moment. You've lost that person because they might not have finished, and they may not tell you that they hadn't finished. So silence is crucial. And it's one of the issues that comes up with investigations when police are questioning Indigenous people. They don't give people a chance to take the time to reflect in the silence. So I will just promote this publication that you got a link to called Effectively Communicating with Indigenous Clients, or some use of those 4 words in some order, which was done by Dr. Lorna Fadden, who's now a lawyer in British Columbia, but is a forensic linguist as well. It's really, really useful, but it talks about silence and the ways in which a lot of Indigenous people use silence and use time between sentences. And you've got to give people that time. You're irresponsible if you don't.
And I would lean into it. It's a perfect opportunity to collect your thoughts, to reflect on what was said. I wish more lawyers took that pause. I think, honestly, the broader point here is that by being a lawyer and representing Indigenous people or introducing Indigenous people into the legal system, you ultimately become a cross-cultural translator, whether you realize it, recognize it, or deal with it. And it goes in both directions. And I think we've been talking about, I think, in one direction in particular for very good reason. But you should be thinking about also how to translate some of the cultural things that we as lawyers engaged in the system do without really thinking about it. And so one example was we were this is in the CHRT case on child welfare, Indigenous child welfare. And we were on one of many occasions before the federal court arguing against Canada. And we had an elder involved that did an opening and the closing. And at the closing, the elder was quite upset. And I should sort of say that we were all on Zoom at this point, so there wasn't sort of in-person care possible. But the elder was quite upset because he had heard counsel referring to each other as my friend. We were calling the Crown lawyer my friend. And that was deeply upsetting in the context of talking about systemic underfunding of Indigenous child welfare in pernicious ways. And likely an elder with some experience of that, either directly or indirectly, we don't know. But this was a very triggered moment for this elder. And the simple word or phrase, my friend, was really the torch. And these are hard to anticipate, but I think things like, had there been a person with the elder, some sort of explanation about what they can anticipate in this space, in this room, some language that will be used. I often now talk about the term "my friend" and I explain it and what it means and why I'll be using it. But that it doesn't actually mean that we spend time at the bar after work, right? Like that, I give that context now, having had that experience. So that's really the mandate. We are cross-cultural translators, and it has to go in both directions, because otherwise you can have these moments where the room is lost, or the moment is really sort of emotional when it needn't be.
Yeah, I think that's really important. I never use the term "my friend." That's for a number of reasons, but that's one. Why I don't want to spend a whole bunch of time explaining what is a stupid practice that I can't really understand anyway, other than someone told me this is what I'm supposed to do. Why should I do that? But and the same thing happens in court. If you're in a criminal court, you're at the front, you're at the other side of the bar, and you're talking and joking and laughing with the Crown, who you may know, and it's important to have a relationship with them. What's your client thinking? And keep in mind, and this is, I think, keep in mind that for many Indigenous people, they have had experiences with lawyers before, and they have generally not been good. They have been, it's either them or their families. They have, if in the criminal context, they've been perceived, they may have pled guilty to things they didn't do, all sorts of awful things. Law has not been a friend to Indigenous people, and lawyers have not been friends to Indigenous people. We know from the residential school litigation that there are lawyers who abused financially and otherwise residential school survivors in order to line their pockets. So you are likely not the first lawyer that people will see. And I remember having a conversation, a very striking and important conversation, with someone who we were talking about when Aboriginal Legal Services was first being set up. And this person had come down from Manitoulin Island. He was a computer programmer and, very successful guy. And I said, so when you came down as a student, if you had had a problem, would you have gone to a community legal clinic? And he said, no. And I said, why? Because they're all the same. It's all on the same side. We make distinctions between Crown and defense, or the prosecutor, or the, whatever, however we define ourselves. We're an adversarial system. There's one side, the other side, and the judge. For most Indigenous people, that's all those people, Crown, defense, judge, they're all on the same team. And that's not because Indigenous people are not sophisticated. It's because that's how it has been. So don't assume that people are going to go, oh yeah, you're this, you're that. I mean, again, the use of "my friend" and "your honor," all that stuff just emphasizes that we're all together on one team. And so keep that in mind, you're dealing with you're not the first lawyer, you're dealing with a history that people will have with lawyers, and hopefully you're helping to make a new part of that history. But you can't pretend that stuff didn't happen. You can't pretend that people don't have those stories in their head. And so you have to work hard by being respectful and, again, taking the time in order to show people that it doesn't have to be that way. But the fact that people see everyone on the same side, that's a very realistic and pragmatic, and in many ways the right way to see it, even though you don't like to see it that way.
And I think, just picking up off something you said there, Jonathan, I think it's important to remember as well that it may be that individual's past, but it's not just in the past that these things are happening. Indigenous people continue to be, in many ways, legally oppressed, legally differentiated from the rest of the population. And it's not surprising that we do see the law as all one thing that continues to not serve Indigenous folks well. And so I think it's it's important to remember that it's an ongoing issue as well. So thank you for that. We've touched on a lot of different questions I had for you, and I want to shift gears a little bit. We've been talking a lot about the issues that Indigenous folks can face, but I want to shift to a little bit of what Akosua was saying, how we are cultural translators. And this is something I know a lot of folks can struggle with conceptually, to identify what are those little cultural bits about being a lawyer or about being just non-Indigenous, or the cultural aspects of our mainstream society. One of the examples I often give people when they ask me, why are we going to start a meeting with a smudge? There's like, oh, there's no non-Indigenous equivalent. And I'm like, well, you just went around the room and decided to touch hands with everybody and then wiggle them around a little bit. That's absolutely a cultural thing. Going around the room and shaking hands with everybody makes no real sense if you look at it, other than it's just this expected thing we do. And so, what are some of the other ways that we can go the other way and try to be bringing in, identifying those things that we do as the majority culture, as lawyers, and identifying opportunities to bring cultural protocols from the Indigenous nations of our clients or the local nations whose land we're on into the work that we're doing?
Well, I think this kind of goes back to how I started, which is go to community and be familiar with those cultural practices, observe them, and ask yourself, is there a way we can incorporate this more into whatever proceeding you're engaging with? And if you're not able to observe it directly, and quite apart from that, you need to ask your client. So, it's not just smudging. It could be the physical arrangement of a room, how people are positioned, putting people into a circle as opposed to at opposite ends of a table. If there's a need to swear an oath, using a feather or having other sort of cultural significant items that can either be used to testify or provide comfort. Really, there isn't any limit, and it should be tailored to the client, because again, the specter of pan-indigeneity can also come into play in this, where you assume that every Indigenous person wants to smudge or participate in these kinds of protocols. So I think that the thing is really to ask that question once you've developed some familiarity as to what would make them feel comfortable in that space. And you can provide some examples of things that you've been able to achieve in the past to spark a conversation, because it may be hard to even come up with it for the client. But be prepared to make that ask. I do think the justice system is to many degrees amenable to this. I've seen it many times where a lot of both coroners and civil court processes have started with smudging or an elder being involved. So I see no reason why it can't continue, or other variations of it couldn't come up in the future.
So just to pick up on those really good points, and then I think, Leslie, what you started with, it's interesting that we think about, smudging and comparing it to shaking hands, which I think is very imaginative, good way to do it. But I also think we should be wary of always trying to find non-Indigenous analogs. So Akosua spoke about feathers. And I find this very problematic sometimes. Holding the feather is like testifying. Well, no, it isn't really. It's like, well, it's holding the Bible. It's not. And if you think about it for a minute, Bibles, Qurans, they're on paper, right? You print them. You can get them. They're not, an eagle feather is not, like there's not, you don't go to a 3D printer and come up with an eagle feather. There are different protocols, different things apply. And we have to sometimes be careful about using analogs, because particularly lawyers, the world revolves around us and our practices, and we're going to then start imposing our practices on Indigenous practices in order to conform to what our needs are. Some things don't have analogs, and they don't need analogs, and that is in and of itself a reason why it should be done. So I think we need to, so you need to learn about some of the practices and why they're important. And I think Akosua was exactly right that you start by asking the client or the people that you're working with what will make them comfortable. Many years ago, I had a fight on behalf of an elder who wanted to smudge the court before the court started and wanted to smudge in court before they testified. And defense counsel was adamant that they were not going to allow that to happen because, well, whatever, there was stupid reasons. But I understand why. I mean, they said to make your client look really good because they're going through all these things. Anyway, you don't answer the question by analog. This is because this is what is needed. This is what they need. And that in and of itself should be an answer, although you are going to have to figure out how you accommodate it. And sometimes things may not be able to be accommodated, but don't reach, I guess my point is, as he said, belaboring this, don't reach for an analog. It can be helpful, but it can also be a trap.
Absolutely. I think you're spot on with that. And that's something that's always made me feel a little bit uncomfortable about the feather, because it does imply it's the same as the Bible, which is not accurate, but I'm glad you appreciate my handshake example. One other question that we had talked about that I would love to get some thoughts on, is we talked about the idea of remedies. And part of the reason we talked about this in our prep call was because the legal system as it is isn't designed to necessarily address the appropriate remedies for Indigenous folks, whether that be because our legal system is based around financial compensation for things which sometimes financial compensation is not enough, whether it be because we have strict rules in our criminal justice system around what must be the outcome. But I also know this is a really big question, and we have been getting a couple audience questions. So I do want to spend a little bit of time talking about this, but I might also stop you in about 8 minutes or so that I can ask you a couple of the audience questions.
Sure.
Yeah.
Yeah, I think there's two things I want to say about this. And I'm going to be referring to the CHRT case on Indigenous child welfare. I think you need to be particularly tapped in with what is happening in your client's geographic region in real time. And also be prepared to come up with and present creative remedies, because there could be a newsworthy event that's happening that allows you to capitalize and present a remedy, and your opponent is actually willing to play ball. So the example about this was we had been arguing for many, many years about whether or not there were any Jordan's principle cases. Canada had steadfastly maintained that there were none. And while this litigation was ongoing, tragically, 2 girls in Wapakika First Nation took their own lives. And it later was, released to the news that that First Nation had actually approached Health Canada and sought funding on a group basis to bring in wraparound services to address what was then known as a suicide epidemic in the First Nation amongst their youth. And Health Canada never responded to it. So we took this real time issue, news issue, and tragedy in a community and presented it in the court before the tribunal and used it on cross-examinations for Health Canada officials. And what it led to was a remedy that a tribunal could never have awarded, which was a choose life order. So for any kind of group application from a First Nations organization or community to Health Canada where there's evidence of need for wraparound services, you wouldn't have to have a bunch of individual families filing applications to Health Canada. The First Nation could do it on a group basis, and it could be expedited and approved. And we created the system for that to operate. And no tribunal could have ever issued that remedy. And the reason why we were able to get it was because we were tapped into what was happening in real time with the community, what was facing the community. And we knew that we had a window. We knew that Canada was starting to feel the pressure of litigation and might be willing to fund something creative. Now, this funding ultimately went to things like land-based programming, right? Which is really important to many Indigenous people, and often isn't a remedy you can kind of directly get in the legal system. But we were able to achieve something here, albeit on the backs of extreme tragedy.
I think that's really important to stress that some of the best remedies are those that will come outside of the system. I mean, people need to know that one of the difficulties with litigation generally is that there's not a lot, not a lot of creative options. There's money, which, it's okay, but it also brings tragedy. I mean, it's a complicated thing. So money is not really necessarily going to address the issues. There are constitutional challenges which can result in laws getting overturned. But again, that doesn't necessarily accomplish what you want. So I think the idea of thinking creatively about remedies, so you engage with they're not your friends, with the other side, and you can come up with those as a way to resolve matters. And I think that's where you're going to the best chance you have to really get what your client or clients are interested in. So it's important to have that discussion with them about what would you like to see at the end, and listen to that, so that the answer that immediately comes to your head isn't, well, you're never going to get that. Because maybe you will get it for exactly the reasons that Akosua spoke about. Maybe you'll be able to get that, but not as an order of the court or the tribunal, but rather through negotiation.
Thank you for that. Thank you for both of you for that. And yeah, the creative thinking about remedies, I think, and solutions is so important. And so now I'm going to shift gears a little bit to some of the questions from participants. And one that I want to start with is, what advice do you have for working with and supporting for example, a First Nations client who you've seen repeatedly for similar offenses? And I think this is also a really great opportunity, Jonathan, to tie into a little bit about what you talked about around the experience with lawyers and the potential of dealing with folks who have, for example, pled guilty to something in the past that they did do for various reasons, or the lack of appropriate services. And so what advice do you have for supporting a client who you've seen in similar circumstances more than once?
So I guess one thing is to try and figure out what you actually know or don't know about the client. So if you've seen the same client 3 or 4 times for the same sorts of offenses, maybe you want to think about getting a GLADU report if that's available to you in the jurisdiction where you live, because that may provide you with information that the client doesn't have. I mean, one of the great things about GLADU reports is that you get perspectives from a lot of different people in the person's life. People who are living in the midst of trauma and difficulty are not often the best narrators or the best people to determine what's going on, because they're living in the middle of all this crap, and it's hard for them to see beyond that. And so I think that's a very helpful thing. Say, maybe if the client may not have wanted, or you may not have thought it was necessary, people keep coming back. It's important to do that. Also, it's important because the court's going to start to get frustrated and tired. Oh, the person's still coming back. We've now, the ladder principle, the step principle, whatever those principles are, which basically move you up into harsher and harsher penalties. Those come into play. So you want to find a way to sidestep that. So that's one thing, I think. The second thing is if you don't have GLADU reports available in your jurisdiction, to speak to the client, ask if there's someone else in the family that you can speak to the client about why these things keep happening. And the third thing I'll say, just mindful of the time, is also keep in mind that people may keep coming back into the system, but that doesn't mean they have not necessarily made strides before. Like we concentrate so much on failure. Oh, you're back, you failed. Well, maybe they haven't. Maybe they actually were sober if they had an alcohol issue. Maybe they were sober for 7 months, and then something happened and they fell off the wagon. But they'd never been sober for 7 months before. So you also want to be able to reshape the narrative about the person away from this notion of failure that fits into all sorts of stereotypes about Indigenous people, and speak to the person's strengths. We all have strengths. We are not simply a collection of our deficits and our failings. And I think sometimes in the criminal context, we just focus too much on those things.
What I would add is, I'm not a criminal defense lawyer, but I think just in general, if a client is struggling, you ought to be thinking about ways you can bring a trauma-informed approach to your practice. And to that, you can look at podcasts like The Trauma-Informed Lawyer by Myrna McCallum. She also ran a really very detailed, intense week-long retreat, professional development retreat, which I attended and highly recommend. And basically, it really just teaches you to look for signs of trauma, because it may not be obvious that your client is actually not doing well. And once you can figure that out, you're going to have a conversation, a very candid conversation, exploring the kind of supports that they have, family members, friends who act like supports, for example, and then determine whether or not you can put them in touch with some more supports. It could be mental health, it could be elder care, it could be just getting them into the family doctor system. And I know that it's not your responsibility as legal counsel to do all these steps, but you need to be aware of other systems and try to figure out ways to put people in touch with supports. And then ultimately, you have to know what your limits are. You're not their counselor. You're not their doctor. And it's something that you should be saying out loud to the client. I am concerned about your well-being because as a human being, also it impacts this case. I need to understand that you're not doing well. And we can see what we can do about getting you some better supports, but I'm not your doctor. I'm not your counselor. And these boundaries are going to be very important if you're going to start to take on, what is now being called a trauma-informed legal practice.
I think that leads really well, actually, Akosua, into another question we had here. And I'm really curious to hear both your thoughts on this one, because for folks who aren't familiar with Aboriginal legal services, they do provide to a degree some of those other services for folks. But do you have any advice, or can you speak to how you learn about what other organizations are out there that you can be helping your client access? Do you build relationships with other services? And how do you do that in a way that, as you're saying, Akosua, also still respects your boundaries as legal counsel?
Yeah,
I'm not sure who wants to jump in.
I can briefly jump in. I think friendship centers are one example. I think you just have to be creating your own internal databases as you go along, and sharing it. So I have created lists of go-to medical professionals, for example, and it is now the firm's list, and reviewing it so that it's diverse, right? So that we're not sending people to only white practitioners, for example. So it is something that takes time to develop, and you need to be capturing this knowledge and sharing it with your colleagues. I also ask the question, look, if I'm looking for a specific resource, I work the network and I say, I'm interested in this. Have you ever come across this? Because really a lot of this stuff is really only discoverable by word of mouth. And so you need to be tapped in, you need to be reading the news, you need to be getting out there, you need to be asking these questions, taking the time and showing the humility to even sort of reach out and gather these resources.
Yeah, I think that's really important. In the criminal context, if you're a criminal lawyer, you know what's available in court. The Sally Ann, there's this, there's that. A lot of Indigenous organizations aren't in court. There's often an Indigenous court worker who can be really helpful in giving you suggestions. But yeah, to be a responsible lawyer, you should be going out and you should ask, you should phone, you should take an afternoon and go to some of the Indigenous specific programs in your community. If you do fly-in work, take some time and see the First Nation, see what's there so you can make responsible suggestions. It's striking but depressing that many judges and many crowns don't go ever outside of the courtroom, even if the courtroom is the gym and the First Nation. Like, they don't go outside to know what's out there. And I think it's really important to do that. And then you'll start to find things. Also, though, keep in mind, and this gets to the, getting back to the very beginning, what does your client want? There are Indigenous people who don't want Indigenous specific programming. Maybe they're Christian. Maybe they were raised as Christians. That doesn't make them non-Indigenous. They're still Indigenous. They're entitled. If they would rather do Christian programming, that's fine. Some Indigenous people go, look, I'm concerned about confidentiality on my First Nation or in the community. I don't want to go to the Friendship Center. If everyone's going to see me go to the Friendship Center, they're going to know why am I going to the Friendship Center. I don't want to go to the Friendship Center. So is there an Indigenous practitioner outside of the Friendship Center? Maybe they want a non-Indigenous person. These are not impossible things to figure out, but they are impossible if you don't ask.
That's a really great way to put it, Jonathan. I really appreciate that. And I think that's a really great spot. That also brings us a little bit full circle to what Akosua started with at the beginning as well, around you need to go visit the community. You need to go do that work. You need to go meet the people. And so I think that's a really great spot for us to end today. And my colleagues will be putting in the chat for folks attending a little bit of information as well about Raven, as well as about our Intervenor Fund, which all the funds raised today go towards that, allowing Indigenous organizations and nations the opportunity to access funding to make strategic interventions in court. And I want to thank both Akosua and Jonathan so much for joining us today. I really appreciate your time, and I do really appreciate, as always, just getting to chat with both of you. We will be sending out to attendees access to this recording, as well as a list of resources that we've put together as well. So thank you so much.
Thank you, Leslie Ann, and good to see you both. And Chimigwech to the questions, great questions, and always a pleasure to be in such fine company.
Yeah, it was fun. Thanks.
Thank you both.
Bye-bye.
Bye-bye.